Good afternoon, everyone. This session will begin shortly. Please take a seat. Good afternoon, everyone. Welcome to panel 11, Supply Chain, Geopolitics, and the Imperative of FDI Screening. We are pleased to have with us a distinguished group of speakers who will explore this important topic over the next hour and a half. It is my pleasure to first introduce our moderator, Professor Locknie Hsu of Singapore Management University, who also serves as the president of SIEL. A quick housekeeping note, this session is being streamed and recorded, and there will be a Q&A session at the end. For online participants, feel free to type your questions in the chat and indicate who your question is for. With that, I'll now turn the floor over to Professor Locknie Hsu to introduce our four panelists. Thank you.
Thank you very much. I had the same issue this morning. Now I've learned how to switch on the microphone. Thanks for joining us for this panel discussion. We have very interesting papers that have been submitted, which I have gone through. And we are going to talk about investment screening in the context of supply chains. So before I introduce the four speakers, maybe I'll just mention how we're going to do this. We've decided that each of the panel members will speak for about 15 minutes to present the area that they've been researching on that relates to investment screening. And then after the 15-minute per speaker session, we will then have a discussion with some questions. I could post them, and perhaps the floor, if you have questions for them, you could raise them as well. And I think online you might have some questions, so will someone be keeping tabs of the question? You will inform us? The person will be audible to us. Got it. Okay, thank you. All right, thank you very much. Okay, so that's the format, and just a couple of quick opening remarks. Why are we talking about investment screening? Because a lot of these sessions about trade and about tariffs and about what's going on in WTO, etc. But we are now turning our attention to another important area of international economic law, because we are beginning to see more and more of these mechanisms in domestic systems which impose investment screening requirements or rules, mainly for inward investment for various sectors, maybe sometimes across the board, sometimes explicitly for national security or essential security reasons. So we have four diverse perspectives on this investment screening in supply chains discussion. I'd like to just first introduce our first panelist, Mr. Jochem. Did I produce that correctly? Yes, thank you. And he's a senior associate at Allen Overy Shearman Sterling, and he specializes in foreign investment screening and competition law. I understand it's like half and half. Okay, so nice mix of issues. And he's also been a lecturer at the University of Bonn, and he's going to be able to talk to us about the European Union perspective primarily. So we'll start with the EU, and then we will move to our second panelist, who is Ms. Agata, do I pronounce it Daszko? Daszko, yes. And Agata, if you haven't encountered her, she's the lovely lady who's been running around helping with all the administrative details, which means that's why she had a lot to do before she arrived here today. So we're very happy that Agata is finally able to sit down and present something about the law rather than something about what you need to collect on the way out, etc. So Agata is an early career fellow in international economic law at the University of Edinburgh. She's also previously been a research fellow at University of Göttingen. And right now she's lecturing in international economic law, trade and investment law, and has teaching and supervision and research responsibilities. The third panelist we have is Mr. James Losari. Let me just pull up. James, can I mention what you just went through? James is in the final year, has been in the final year of his doctoral study at the City University of Hong Kong. And James just recently defended his thesis, I suspect very successfully. But he's going to look and sound very modest. And his dissertation focuses on a comparative study of procedures for taking evidence in international arbitration, where he analyzes the procedures found in civil procedural laws of selected common law and civil law jurisdictions. And he has dual qualifications as a qualified advocate in Indonesia and a solicitor in England and Wales. I could keep reading, but I will not. And of course, finally, we have Ms. Huang Jiaqi, who is a PhD researcher, PhD candidate in the City University of Hong Kong. So they will each give us a different slice of this supply chain investment screening discussion. And we will begin with the presentation by Jochem. And Jochem's presentation, if I understood it correctly, will mirror what's in the paper you sent us. It's entitled Supply Chain Resilience as Economic Security Interest in EU Investment Screening Law, after which Agata will talk about the UK screening law. So I can invite Jochem over to the other microphone.
And thank you for the invitation to speak here today. When I started practicing around 9 years ago, when a transaction would come in, we would often be asked to do a check whether the transaction would require merger clearances anywhere. So we would do a multi-jurisdictional merger control assessment. And except for the case in which the company was active in the area of defense or critical infrastructures, you wouldn't really think about national security in a way. Now, that has completely changed, and for every transaction that we do, we also need to verify whether it needs to be notified under investment screening rules. Around 1/3 of the transactions that we do at A&O Shearman require notification and approval under investment screening laws. So that covers really a substantial part of the investment scene or climate. And as part of my PhD, I also write a PhD thesis. There's a little bit of an echo, right? Is it okay, or it's good? I write my PhD thesis on investment screening. A key question, of course, is what is security in the context of investment screening? And we talked a little bit about technology leakage in the earlier panel on semiconductors. And what I will be talking about is supply chain resilience as one of the key factors in investment screening, or the key screening criteria as one of the aspects for which governments check investments. And this interest really emerged in the context of geopolitical tensions, the pandemic, in the context of shortages of medical equipment and protective equipment, and the energy crisis following the Russian invasion of Ukraine. Now, what is supply chain resilience? Essentially, it is the capacity of the EU to resist, adapt, and recover from disruptions of critical input supplies. It relates to the capacity to address strategic dependencies. Are you sure that there's not a back? I'm hearing a lot of. Thank you. The capacity to address strategic dependencies. If there are dependencies of the EU on a third country, those can be weaponized, right? There can be cases of economic coercion. Supply chain resilience has a very broad scope, right? Both in terms of the type of disruptions that government tests for, as well as the sectors that are covered. So it's not just about refusals to supply, where there can be a refusal to supply by a third undertaking that is, holy shit, can I move somewhere else? Okay. But it also relates to the decrease of quality or quantity or delays of certain inputs. You see furthermore that the discourse is generally broadening to, maybe let's just do it like this. The discourse is generally broadening to like the entire internal market. So the stability of the internal market as such becomes a supply chain resilience interest. You also see in economic security strategies that interests such as price surges become part of the economic security paradigm. Right, so we're not just talking about a complete refusal to supply oil and gas, but we're talking about price surges, general dependencies being weaponized, a delay of supply. This also is closely related to the availability of critical technologies and not just inputs, historically associated with security interests like oil and gas. Now, if we look at the type of critical inputs that are covered, we can start with, well, there are many of them, and they essentially span across the economic spectrum. If we start with energy, it's an obvious one, right? So we have some older case law, which is Elf Aquitaine, for instance, a case brought by the European Commission against France for having a golden share in Elf Aquitaine, what is now Total, like the major French oil company. And they targeted this golden share, and the court said, quote, in the event of a serious crisis, France could effectively ensure its supplies of petroleum products only by requisitioning the crude oil reserves of Société Nationale Elf Aquitaine, located abroad, mainly in Africa. However, that would be possible only if the company's central decision-making body remains in France. In order to get access to those oil supplies in France, the company had to be located in France. Now, it is quite obvious that oil and gas falls under this, but now we are moving beyond that, right? So there are concerns about Chinese EV manufacturers in Europe, often greenfield investments. And the concern there is as well that there could be dependencies on Chinese EV manufacturers or battery manufacturers, even if they are located in Europe. So for instance, Draghi has proposed that there should be JV requirements in order to further strengthen the resilience of European supply chains. Then moving on to healthcare, you had the COVID-19 pandemic, where there was a general shortage of medical and protective equipment. Trump tried to acquire CureVac, which is a German company, in order to get exclusive access to vaccines, in order to serve American citizens first, to the detriment of the rest of the world. Clearly a supply chain resilience issue. Germany also prohibited, for instance, the acquisition of Haier Medical, which is a ventilator company, by the Chinese company Aeon Med Group. So here as well, you see it's about vaccines, medical equipment. It's a wide variety of companies that are being targeted under the nomer of supply chain resilience. Moving on to food, another critical area. You had the case of Carrefour Couche-Tard. Carrefour, the famous French supermarket chain, Dialofood called in, they're also here apparently. And Couche-Tard is a Quebecois company from Canada, not a typical sort of like state-owned harmful investor, just like a French-speaking, just an investor from a French-speaking part of Canada. However, even before this transaction was notified to the French ministry, the French minister went into the press and said, my answer is extremely clear. We are not in favor of the deal. This no is polite, but it's a clear and final no. And this happened even before the transaction was notified to the French government. Then also in Italy, the acquisition of the Italian subsidiary of Verizon, which is a partly Dutch company, partly Italian, etc., by Syngenta, which is owned by ChemChina, was prohibited. And there it was considered that contract with Italian farmers, quote, can affect the national agri-food chain, so also seed production. Critical raw materials, quite obvious, right? There's also the anti-coercion instrument, Critical Raw Materials Act. I'll get back to critical raw materials later, right? Huge dependency on China. Moving on to critical technologies, we've discussed technology leakage or control over technology, but also there's the question of access to technology. And perhaps one of the clearest cases is actually what the US is, the US policy vis-a-vis China in respect to the semiconductor sector. The US essentially afraid that Chinese companies would acquire US semiconductor technology through non-US firms, decided to expand its export control regime to state essentially that as long as a product or technology has US items, US technologies that are controlled, the non-US or ex-US technology or item is also controlled by virtue of containing US equipment, right? So it's a large extraterritorial application, which was then leveraged vis-a-vis the Netherlands in respect to ASML, which contains US export control. US said, essentially, you either stop exporting the EUV lithography machines, equipment to China, or we will start blocking that instead for you. Now, this type of economic coercion also happened in relation to Japan, South Korea, and Taiwan. Of course, this impacts the EU's ability to impact trade. In return, China responded by imposing restrictions on critical raw materials, as we just discussed. In turn, China leveraging its dependency or the European dependency on China for critical raw materials. Briefly on outbound investment screening, there's now a recommendation by the European Commission to start looking into whether we should also start reviewing outbound investments from the EU into third countries. The focus there has been on the leakage of technology, but a key question is also, how about supply chains? Are we also going to protect or prevent the offshoring of production or technology in order to protect supply chains and ensure the resilience thereof? Now, how to assess this before I move on to my conclusion? Interestingly enough, like, these methods are somewhat similar to competition law. So you look at, for instance, the market concentration, right? What are the relevant markets? What are the market shares of different participants? Who are the alternative suppliers? Where are the alternative suppliers from? What are the switching possibilities? If one company would stop supplying, would it be possible to switch to another company instead? This also helps explain the focus on energy, telecom, and semiconductor technologies, because these markets tend to be characterized by high concentration, limited alternative suppliers, and limited switching possibilities. Now, in conclusion, supply chain resilience, covering almost the entire economic sector, ranging from food security to healthcare, from energy to semiconductors, is representative of a broader trend or shift away from liberalization as a key focus or paradigm of investment law or investment regulation to security as a central paradigm of investment regulation. The methods in order to assess this are similar to competition law, but unlike competition law, where there is a clear set of framework, clear regulatory framework with a focus on market power, here the question is there a risk of political coercion in the end? It does not mean autarky. There is also a trend towards ally and friendshoring, but nevertheless, the increasing importance of supply chain resilience represents an important paradigm shift in international investment regulation. That's my presentation. Thank you.
Thank you, Jochem. So what I took away from that, I was hearing that the motivations for having these investment screening mechanisms or regulations could be different motivations. It could be geopolitical, strategic. It could be because you want to have remove the dependence on the sources of your supplies. For example, you gave the pandemic example where the medical supplies or the medical equipment supplies brought out the issue where you're very dependent on certain sources. So that could be a motivation, right? So the motivations could be different. And so in that regard, the regulations have to be designed to capture what these objectives might be in different sectors for different reasons. So if I heard that correctly. So I have a few questions. I'm sure the audience does too, maybe. And maybe we will then move on to the second panelist, Agata, who will then give us the UK perspective, because I understand that it came soon after the EU system was put in place. So this is a nice segue into the UK version of what's happening. Agata, please.
Good afternoon, everyone. I normally start by thanking the organizers for having me here. I am very thankful to SIEL for this opportunity. I will be presenting my paper on entitled Watching the Watchmen, the role of national courts in investment screening evidence from the UK. I'm hugely thankful to Jochem for doing all the hard work, so I can dive right into it. While the paper is about the UK regulatory framework, it goes deeper than simply describing the Act. It examines the role of domestic courts in the UK in adjudicating investment screening decisions that are made under the National Security and Investment Act, NCIA 2021. It is part of a broader project exploring how international economic law is being domesticated nowadays, that is brought into the national legal order through regulatory, judicial, and administrative actions. There is, of course, a rich literature on how states attract foreign investments, how they should attract foreign investments, and probably even richer literature on what happens when that relationship breaks, how states and investors resolve disputes, ISDS. What is less frequent is the study of what happens in between, the domestic life of the investment. This paper, as it is, aims to fill in that gap by exploring how regulators and courts within the UK navigate this legal landscape. The NCIA represents the shift we are seeing globally, this recalibration of investment governance to place national security concerns at the center. But unlike some regimes, unlike EU regimes, the NCIA is country agnostic. It applies to, it does not differentiate between foreign and domestic parties. It applies to all acquirers. And it's this language of acquirers. There's no word investor in the Act. And it does, and also, as it is with those issues, the term national security is not defined. It's left deliberately open-ended. It's regulated by secondary legislation. The Act applies to acquisitions across 17 sensitive sectors. And if the shoe fits, it will fit into one of the sectors. Communication, data infrastructure, of course, military uses, but energy, transport, artificial intelligence, and so on. And education. The Act introduced a mandatory notification regime for certain acquisitions and voluntary for others. So a transaction must be notified if it constitutes what's called a trigger event. So, for example, when sorry, thank you. When a person holds a UK company, when a person holds in a UK company, when shares that a person holds in a UK company increase, for example, from less than 75% to more than 75%. What is interesting, and where a lot of my research comes from, is that the transactions can be also reviewed retrospectively with the Act covering with the Act dealing back to 12th of November 2020, when it was first introduced to, well, when it was introduced to Parliament. Even though it then came into effect in 2022. The statutory scheme empowers the Secretary of State to review, block, or unwind acquisitions deemed to be to pose a risk to national security. Thus far, there have been more than 2,000 call-ins or voluntary call-ins as well. Only 33 of them actually resulted in review, a block, or an unwind position. So some of the examples would be a joint venture between University of Liverpool and a Chinese Institute of Advanced Energy, where the transaction was cleared, subject to establishment of insider threat stakeholder group. And this happens throughout. And actually, for us in the UK right now, we are receiving emails from universities telling us that we do need to inform them when we are actually working in something that might be deemed infringing on national security. I haven't told them I was going to Taiwan. So at the same time, so the two big ones are the two examples that I have are acquisitions of semiconductor plants in the UK by Chinese companies. There's one called FTDI. Unfortunately, they don't have interesting names. So the Chinese company has acquired 80.2% of shares in a UK-based chip making plant, and the UK government has ordered it to sell all of its shares. Judicial review is currently pending. Interim relief for application has been refused. Another big example that actually has resulted in a judicial review has been the acquisition of a broadband company by people, and that was back in January 2021, by a company whose owners were connected to Russia. To Russian state, they were Russian, and then when Russia invaded Ukraine, they have been put on sanction list. So UK then the government went and ordered a divestment order. So at the same time, the NSAA provides for judicial review. There's no appeal mechanism under the NSAA, but there is a judicial review of the decisions. And here the domestic courts act as institutional watchmen, reviewing executive decision-making for legality, rationality, and so on. Procedural fairness is a big one as well. So what does it mean in practice, and does it insulate the state from exposure under, and this is the question, under international investment law? So in letter one, the judicial review has been has failed. So this is the Russian case. There, the court has looked into rights of property under Article 1, Protocol 1 of the ECHR, and said that the regulatory action was justified and compensation was not required. How would that work out under ISDS regime? That is the point. That is the question of the papers that I'm looking into. Same with FDI. The FDI has applied for an interim relief that has been rejected, and there's a question of whether that could potentially breach an FET clause in the UK-China BAT on the level of denial of justice. Both cases at the same time do demonstrate that while judicial oversight exists, it may be procedural rather than substantive. Courts are very reluctant to look into the decision-making of the state. In both cases, the courts decided that national security does not imply review, that the state has a huge discretion in deciding what is and what isn't national security, a story that we know from other dealings with national security. At the same time, the paper does not take a position on whether the claimants in letter 1 and FTDI would qualify as protected investors. It rather than looks the step ahead on whether there could potentially be a breach of investment protection. Under the FET, denial of justice is, of course, a recognized element of an FET breach. It has a very high threshold. It has to shock a sense of judicial propriety. It would probably fail under the FTDI, but it's something that the UK government has not really thought about. From my conversations with the DBT, it's something that they are only now catching up on, that they have those responsibilities under international investment law. I think the claim of indirect expropriation, as with letter 1, is a little bit more interesting and a little bit more likely to go somewhere. And it's to do with compensation, of whether, even if it was done for the right reasons and public order and so on, it's whether under existing BITs that would be affected, and it's not the new ones, it's the old ones, whether UK would be found liable because it did not offer compensation by, for example, connecting it to cases in ISDS, such as PL Holdings versus Poland, where the Polish Bank Authority has also, in a way, told PL Holdings that they have to divest. And in that case, PL Holdings was found liable, Poland was found liable, and whether this would apply here, I think it's an interesting mental exercise, but it's also a real question. How long the investment has existed for and what not, that also, of course, comes into play. But it's something, again, that needs to be reviewed, and it's not being reviewed, of course, by domestic courts. Domestic courts only apply domestic law, which in the UK also still encompasses the ECHR, right to property. Now, the right to property is akin to expropriation, but it's being looked at very, very differently by EU courts, by European courts. The paper does not argue that the NSIA is flawed. It does not attack the NSIA. I do believe it is a carefully constructed piece of legislation and does reflect the UK's, let's say, regulatory needs. It does suggest, however, that regulators must approach its enforcement with a broader lens. They do have to look into international commitments that UK has signed up to previously. The nice thing that the Act does is that it does provide information. So at every stage, the acquirers that are affected can seek information from the government. The takeaway is not to necessarily constitutionalize investment law, nor to internationalize judicial review. That is not really something we can do. Rather, it is to recognize that regulators must also watch the Watchmen. The regulators have to have a look at what the UK courts are doing, whether the judges have the capacity to review those decisions, looking at broader implications of those decisions. They must be attuned not only to what the law permits domestically, but also to how their decisions may be received internationally. From my conversations with some people in DBT, so that's the Department for Business and Trade of the UK, it becomes clear how surprised they are that those cases actually come into research, that people are looking at them. They thought they wouldn't be, it wouldn't be something that academics would be that interested in. However, I think from the ISDS perspective, it becomes clear that this is something that we need to look at to the future. Thank you very much.
Thank you, Agata. Just out of curiosity, am I the only one that's not knowing what that chime is? That musical chime? Where's that coming from? Oh, it's the university bell. I see. Okay. I thought it was coming from the screen or something. Yeah, thank you very much so far for keeping time. Appreciate that. Maybe just with James's indulgence and Jiaqi's indulgence, maybe we just break off for just very short questions right now while it's fresh in everyone's minds with the EU and the UK approaches before we get on to more sort of Asian context that you're going to talk about. So can I just open the floor very briefly for any questions for the first two panelists? Yes, please. Could you get a microphone and tell us where you're from, sir?
Hi, I'm Manu from University of Exeter. I have a question for Jochem about the discussion about the French acquisition. The case was Carrefour, I believe you want to discuss. Did you ever think maybe there were other sort of strains of reasoning behind the French government's decision? I know there's another case, if I remember correctly, there was Danone, the yogurt company, that was also being subject to a potential acquisition, which was blocked on national security grounds. And the discussion at the time was, Sorry, I'm not sure if I did that, but anyway. So there was a discussion at the time about it being the crown jewels in the French economy and a very traditional French brand, and it was sort of hint of economic nationalism there. So have you considered, any kind of nuance in terms of what and why and where these decisions are coming from? What sort of lies behind that motivation?
Turn that one off now, otherwise. Okay. The Danone one, of course, is a bit older. Pepsi tried to acquire Danone. Was it in the 90s, I think? It was blocked on national security grounds. Or at least they wanted to block it. It was never formally blocked. I mean, with Carrefour Couche-Tard, of course, like the minister went into the press a couple times, and that's pretty much the only thing we know about it. The minister stressed the importance of French food sovereignty. It stressed that Carrefour supplies around 20% of the food in France, and that it's an icon of French, that it has strong relations with France, and that it's important that it's a French company. So he tied it back that the justification for the block is security, right? They cannot say, well, they have to say it's security because they have to block it on some ground. So they argue that these interests relating to food security under maybe French ownership would pose a threat to French food sovereignty. I mean, it's all pretty. It's a pretty expansive interpretation of security, let's say, right? It really blurs the boundary between what is law, what is politics. I generally critique this, but that's almost inherent to the security exception, where it would be difficult for a court to say that Carrefour is not important for French security because, well, if they supply 20% of the food, et cetera, if the government says, well, I mean, maybe we need to re-acquisition like the food supply chains by Carrefour, and it's important that it's under French control. Who knows? Maybe the European Court of Justice will say, in principle, food security is an interest that can be protected, but this measure was not proportionate, or this measure was not necessary, or it could have been addressed through other kind of mitigating measures. But you as an investor, it's the question whether you want to have like 4 years of legal battle, or whether you're just going to say, okay, well, never mind. And in most cases, the second applies. Yeah.
I see 2 more questions. So perhaps gentlemen first. Yes.
Yes. So my name is Balint. I'm from the University of Szeged, that is Hungary. So I just to Manu's point, I think with France, and I'm not an expert in this stuff, but I'm attempting sort of to be to understand a bit more about how some countries perceive how they go about their economies. And in France, you have this concept of dirigisme, which is, okay, so some people do know about this. I just came across it a couple of days ago, and it's something akin to what we saw in the case of the Asian tigers, and we're in one of them, of heavy state involvement in certain sectors of the economy, more than just regulatory intervention, a more forceful intervention in the economy, so to say. So I think in France that's interesting, but take it a bit further from food security and all sorts of other dimensions of security, I guess, which are now proliferating, right? I didn't know about the case with the University of Liverpool, but I've been looking into research security lately because I find it very interesting that there are certain open source intelligence companies and various other entities producing reports that talk about worrying developments in the area of research. And when it comes to advanced energy type stuff and real sciences, I understand it. But when I see in these reports that you also get social sciences included, I find that to be at least ridiculous. I mean, what we do is mostly talk about what other people had talked about, right? So being open about stuff and thinking out loud is what we do. We don't really do secret stuff that need any kind of NDA or anything. And still, it's being included in this area of research security as a worry of some sort. So just some reflection points. Thank you. Not really questions. Not really questions. Yeah, not really questions. Just thinking out loud.
Thanks. Greg Messenger, University of Bristol in the UK. Thanks, really interesting presentations. Yeah, Agata, a flashback to a lecture from the university telling us grant applications, if you're in any of these sectors, you know, make sure, and it's over a certain amount, make sure you check with our risk management to make sure that it's all okay. The sectors are so broadly defined. You know, you start the list and you think, well, that's quite sensible. And then by the time you've finished all 17, you think, right, well, what isn't covered by this? Which really goes to the heart of the question in both systems. How do you, is it useful to have a sectoral list at all? Or how do we deal with this? And I come from this thinking of it primarily from a trade perspective, where you mentioned, Jochem, you mentioned the pandemic. And of course, the lesson from the pandemic isn't, oh gosh, look about resilient supply chains. The lesson surely was anything can be a critical product if you don't have it. So that in terms of am I interested about the sectoral approach and if it's worth having at all, if that's something we should be thinking about, and again, perspectives from the UK and the EU side would be welcome. Thanks very much. Really interesting papers.
Also, if you think about the other side of it, so if it's, even if you say that sector or that asset is critical, what about the investor? So in the French case, are they really trying to tell us that in times of sudden crisis, the Canadian government will deprive the French population of its food, supply chains? I mean, that's, again, that seems implausible, no?
If I can just jump in. I think there are two things. One, when it comes to universities, I wonder if it's also to do with financial dependence, that the government does not want universities that are already financially dependent on Chinese students to be financially dependent on the Chinese state, to put it in quite cynical way. And in terms of, yes, it can be anything, but also it's not anything, right? It's one of those conversations of, oh, you know, it could be, I don't know, a puppy farm, like it could be anything. Yes, of course. But if we're looking at what, and this is why I actually like doing this sort of research, because we are looking at what is happening. And 98% of transactions get cleared. And out of the ones that are not cleared, I think only about, if you put it into percentage, only 7% actually go into divestment or blocking, or most of them are then, the other ones are cleared with conditions. So those centers are happening. Those, there are many investors from, let's say, friendly countries that are also caught by that. So there is a Canadian investor who was investing in something to do with military, and one of the conditions was that somebody on the board had to always be British. Those little things. So I think it would be the same conversation if it wasn't sectoral. If it wasn't sectoral, it would also be, well, it can be anything. Well, yes, but it also can't, today, in this day and age, it can't be just guns and tanks. That's, yeah.
So the Watchmen are watching the clock. And we have one more question, and then I will invite James after that. Could you please tell us where you're from? Thank you.
Okay, I think I'm loud enough. Michelle Limenta, I'm from Indonesia, Universitas Pelita Harapan. No, I'm just like follow the colleague at the back questions about FDI screening on food security. I mean, I'm not FDI or I'm not investment person, but I'm thinking, is that against the very purpose of food security? You really need collaboration, cooperation. And by you're doing it, I mean, by FDI screening is kind of like limit. I'm not sure what is this FDI screening, the purpose, or whether it's a limit. But in food security, we need collaboration, we need cooperation, we need sharing. How this gonna be achieved? I mean, the purpose or the objective to be secure. I mean, for food security. Thank you.
So maybe I'll start with a sectoral approach and then I tie into food security. So within the EU, you see that the FDI screening regulation provides a lot of leeway for the member states to determine what investments they want to screen. So for instance, food is not covered by the Dutch investments screening regime. For instance, also in the area of energy, the French regime and the Spanish and Romania, Hungary, Sweden, Denmark will say investments that touch upon energy. In the Netherlands, it says acquisitions of LNG facilities or acquisitions of electricity plants with a nominal electricity capacity of more than 250 megawatt. In Germany, they have also something like that. Right? So there are flavors of what you can achieve. Actually, the UK is also sort of like in the middle of like saying, okay, well, energy is covered, but for instance, it relates to offshore oil and various other industries. So there, the sectoral approach is there, and then they varying depending on the country, they will try to narrow it down more. In the UK, the Netherlands, Germany, a little bit more than let's say in France. And that ties in with the French approach to national security, where and the concept of dirigisme, where the French state will just say, no, but we have this power to regulate the economy. Now, surely that is a noble objective, perhaps, and maybe that's a way of governing your economy. But my argument as a lawyer is that you cannot just do this on security grounds, because you make everything a security ground in that case. If you try to regulate your entire economy based on the security exception, everything is security. Security means nothing. And then there are severe difficulties in subsequently challenging that before a court. So that's why I think it is important to realize, okay, well, maybe the previous investment regulation system is no longer appropriate. Let's figure out something else with defined norms. Let's define what we want to protect, and then let's define the interest. Let's say supply chain resilience. To what extent do we want to protect supply chain resilience? Like, what kind of market share should we be concerned about? I think in the case of food security, I think this is a very much like a protectionistic decision by the French government. Carrefour is a national icon. It's like acquiring Ford or something like that in the US, right? It's an icon of what France is. There's a Carrefour in every single little village. Everyone goes to Carrefour all the time. It's an icon of what French is. And that icon not being French, just like Danone is like French, is unacceptable for the French Ministry of Economic Affairs or the Treasury, and therefore blocked based on very dubious security grounds.
Thank you. I'll invite James to make his presentation. He's going to give us a discussion of analysis of Asian countries' investment screening mechanisms. James.
Good afternoon, everyone. It is my pleasure to be here. So we have heard about the investment screening mechanisms in Europe and also the UK. So what I will try to do now is to take you on a tour of the investment screening mechanisms in a continent that is closer to us now, or where we are now in Asia. So basically, this research is based on the background that the existing literature investment screening mechanisms have mostly looked into or focused on the ones that is introduced by the global north or developed countries, such as Canada, the US, and also the EU. But when we look into the investment screening mechanisms in Asian countries, this is very much overlooked. There are some literature that try to compare the US investment screening mechanism and that of China, but it is still very limited. So that essentially is the background. And what I want to highlight in this research is really one that screening or investment screening mechanism based on security reason is getting louder and it becomes the center of legal design. It's no longer an exception. And even in Asia, we are seeing countries implementing investment screening mechanisms as well. But what we see also, the secondly, is that there is no uniform model of ISMs. We do not see this in the global north in developed countries. We do not see that as well in Asia. There are differences that I will highlight later. And lastly, that some of these ISMs in its application may breach the investment obligations of the Asian countries. And by understanding these potential obligations, then we can provide recommendation on how these Asian countries should shape their investment screening mechanisms. In terms of the jurisdictions that I analyze in this research, I limit to these 4 countries, South Korea, China, Japan, and Singapore, for 2 reasons. One, that they are some of the main recipients of FDI in the region. And secondly, because these are the countries that have recently revised or introduced ISMs in the last 5 years or so. I'm not saying that it may be the case that further analysis could be done for other countries, for example, more countries in Southeast Asia. But at this point, I think limiting to these 4 countries could be very useful. In terms of the scope of analysis, as I mentioned, this is a comparative study of ISMs. So partially, it may be a little bit descriptive. But at the same time, this descriptive nature is very important to understand better the regulations in each country and further on apply the compliance analysis. So these are the main findings of the selected countries' ISMs. I will not go into the details of the legislations of each country, but first of all, what I want to highlight is there is a lack of uniformity in terms of the model. There's no particular model indeed. One thing that we can note, though, security is mentioned in all of these countries' ISMs as one criterion in the investment screening. And when we discussed earlier about the question about sectoral, whether or not it's even useful to have a sectoral list, what we are seeing in these Asian countries, they all have sectoral lists to begin with, but at the same time, they still have the catch-it-all phrase. So, for example, in China, the investment security investment screening mechanism, the relevant legislation mentions and other important sectors. So it is left very broadly, leaving a lot of discretion on the government to really determine what kind of sectors that may be subject to investment screening in the future. And I think this probably, there is a logic to it, in the sense that there might be areas that or sectors that the government hasn't really thought about, but potentially could raise some security concerns in the future. Just like how artificial intelligence was never thought about, or cybersecurity. So it could be the case that in the future that there may be other sectors that appear. In terms of the scope of what is being screened, in terms of the transaction, so it actually diverges a lot. So in China, for example, the types of transactions which are being screened are actually quite broad. It covers both M&A transactions as well as greenfield investments. But there are some countries that actually excluded screening for greenfield investments, such as Japan. So in Japan, the focus seems to be very much more on the screening for M&A transactions, particularly for military and defense sector, as well as for technological sectors. This is also the case in South Korea, but South Korea also covers greenfield investments. in terms of various types of screening mechanism, so there are some mechanisms that require pre-transaction notification. So prior to establishing your investment, then you have to provide the notification, and then the government will start conducting the screening mechanism. And there is also some South Korea, for example, is quite strict that if you want to invest in defense and military and national core technologies sector, then these will require certain approval by government agencies. What is standing out as being an exception is really Singapore. So Singapore does not require pre-notification transaction, but what it requires is a post-transaction notification. It is a very different approach. So one question that I really look into as well when we talk about investment screening mechanism, at the same time, this gives an impression that the country is being protectionist, right? So how did these countries try to balance between attraction of FDI and protecting national security? So I identify there are different ways for them to do so. For example, if we look at China, while having a national security or national security measure, that's what the law is called, they also try to provide an impression that China is still open for business by reducing the negative list. So over the years, China has actually reduced the negative list more and more, giving an impression to the investors that they are actually quite open. The other countries, such as Japan, they limit the investment screening mechanisms only for M&A transactions, but greenfield investment is still quite open. For Korea, I think the way that they try to balance is that it is also quite limited in the sense of the focus of the investment screening mechanism for South Korea seems to be very much on the high-tech technologies and strategic technologies that is considered, certain technologies considered strategic by the government. Whereas in Singapore, I think this is an interesting, again, as an exception compared to the other rules. So Singapore applies the investment screening mechanism not only for foreign investment, but also for domestic investment. So it gives an impression that this is really done for the national security concerns rather than really to block certain investments coming from certain countries. And one thing that I also want to highlight of all these four countries' ISMs, actually they are quite different than the ISMs of developed countries in the sense that they are done or designed in a non-discriminatory way. So it does not identify countries which are exempted from the investment screening mechanisms, such as compared to the US investment screening mechanisms. So based on this, then I did the compliance analysis. And for the purpose of the compliance analysis, I limit only to two FTAs, the CPTPP and RCEP, because these are the relatively more modern FTAs. And in terms of CPTPP, we know that Singapore and Japan are parties to it, but not China and Korea. But for RCEP, all of the countries are actually parties to it. So the disciplines that I looked into are non-discrimination principles, national treatment, and also MFN, and then fair and equitable treatment, and also expropriation. So my finding is that first, in terms of MFN, as I mentioned earlier, given that by the design of the measure, what we are seeing is that probably there will be less likelihood of a claim of breach of the MFN principle from the juror, because these measures do not create certain exemptions for some specific countries, except probably I want to highlight Japan, because Japan's investment screening mechanism does provide a sort of like a reservation that it will not, the investment screening cooling off period applicable under the investment screening mechanism, which means that this is a period where you cannot do your investment while the review is being conducted. it will not be applicable to those investments coming from countries who have certain arrangements or agreements with Japan to prevent this kind of investment screening mechanism. So that potentially can be a breach if it is applied in practice. Now, in terms of the national treatment, I believe that by its design or by its nature, the investment screening mechanisms tend to be in breach of the national treatment obligation. Of course, there are certain further criteria or elements that have to be assessed, such as like circumstances. But if we look at Singapore's investment screening mechanism, given that it's applicable for both domestic and also foreign investors, the national treatment breach concern probably is not going to be there. One thing that I need to mention also with regard to the non-discrimination is that when we talk about these two, then there's also a question about this investment screening mechanism really concerns about in most cases, it concerns about the pre-establishment stage when the investors are still making their investments. So what I found under these two, CPTPP and RCEP, actually some of these countries have made explicit reservation in their non-confirming measure list to say that investment screening measure will not amount to breach of the national treatment or MFN obligation. So these are Japan and South Korea. So in their treaty negotiation, they actually consider this already. Now, in terms of fair and equitable treatment, this is actually I will not go into too much detail because Agata, I think, very helpfully already mentioned about the standard of denial of justice. So there's a question whether or not in the process of investment screening mechanism that there could be denial of justice concern. So in these two agreements, from what I've seen, the CPTPP, the fair and equitable treatment clause, seems to be applicable only to covered investment, meaning that the investment has to be established already. So there is possibility for state to argue that at the pre-establishment stage investment screening mechanism, probably this will not become a breach of the fair and equitable treatment clause. But of course, lack of due process in itself could potentially be a breach, but this will have to be analyzed in a separate way. And the way I will look at it is actually quite interesting in terms of this standard. When there is unclear reasoning from the government or there is a denial of the opportunity to be heard, then potentially there's a breach of this fair and equitable treatment. What we see in the ISMs of Singapore and Japan, they are actually quite explicit in providing that there will be an appeal mechanism towards the decision by the screening agency. But we do not see this in China and South Korea. However, one could argue if there is an administrative review available before the courts in China and South Korea, then fair and equitable treatment probably will not be breached. In terms of expropriation, divestment requirement potentially could amount to indirect expropriation, as Agata already explained. And the only country with ISM that probably has this possibility is with regard to post-establishment stage will be Singapore, because the ISM has okay, I will just conclude here. The ISM has a broader nature that it is applicable also at the post-establishment stage. So I will leave you here with that, and I will welcome question and answers further later.
Thank you very much, James, and thank you for keeping to the time. In the interest of ensuring that we have a little time left for questions for the two panelists, I propose we move on to hear Ms. Jiaqi's presentation. Please go ahead.
Okay, good afternoon, everyone, and thank you for having me here, and thank you for all the wonderful presentations. And we have just heard about a more general aspects of FDI screening mechanism from EU to UK and to Asia Pacific. Now I'm going to delve into a more specific aspects that is highly related to our daily life, that is cybersecurity across the supply chain, which I call CSASC, and in the FDI screening mechanisms. So actually, my PhD research is focusing on how the cybersecurity regulation can be integrated into the international economic law. And as the deepening of my research, I started to realize that the cybersecurity concerns of the countries is actually come from the digital weaknesses along the supply chain, especially when it concerns the security of a critical infrastructure. So we can see a vivid example here. That's the 2020 SolarWinds breach. And this case illustrates how an attacker can turn everyday supply chain processes into a powerful weapon. And in this case, the attacker used a routine software update to gain access to internet system. And this allowed them to disturb the governments and private entities around the world. And while the key target was the US, the other countries are also got influenced. So similar case, we can also see the 2017 NotPetya incident that relates to the Russia and Ukraine. So the NSA, a European Cybersecurity Agency, has issued a report that the supply chain attacks are expected to become the world's leading cyber risk by 2030. So I found this very interesting, and governments are started to responding. And in an international investment arena, the countries are using FDI screening or relevant mechanisms to combat this, and which I will elaborate later more. And through literature review, I found that there are two things missing. First is a lack of a comparative perspective. Like most of the literature are now focusing on a single jurisdiction perspective without a multi-jurisdictional perspective, which is crucial for the evolution of IIL and the global cybersecurity practices as a whole. And secondly, most of the literature broadly examines the relationship between FDI screening mechanism, supply chain security, global supply chains, and the IIL as a whole, and with some specific attention paid to the environmental protection or human rights. So it is unclear whether the principle that applied in those cases can be applied to the cybersecurity context, or if there is a new or specific cybersecurity standards can be applied here. So this leads me to my research question. First is about the definition. What exactly is the cybersecurity across supply chain? And how does it relate to FDI screening mechanism? And the second, here I took a more comparative perspective to look at the EU, PRC, and US to examine them. How are they address the challenges in light of the economic, in light of these challenges? And the reason I choose these three economies is that they are the major economy, they are the major digital economy participants in the world, and their practices are prominently shaping the global cybersecurity landscape. And the third question goes to what legal or policy reforms are needed to balance the CSASC concerns and investment facilitation in the IIL context. So delve into the definition. Actually, the definition of CSASC has been existing quite long, but it started from, not from a legal concept, it starts from the supply chain management. So here I borrowed the definition of supply chain management, and according to Magni and others, the CSASC is referring to a holistic systems approach that involves technology, procedures, and people to protect network, systems, devices, and digital assets from breach due to the organizational targeting and exploiting weaknesses in the supply chain network. And how does CSASC matter for FDI screening? I found 3 scenarios. The first is under the context of when investors try to acquire or control critical infrastructures or the critical suppliers or technologies. So the countries might have a concern that this will introduce vulnerabilities like backdoors or compromised components into the essential systems. And the second is when there is an issue of relying on foreign control suppliers. And the country is actually examining whether the investor is using a foreign software or hardware that can expose to a country to the hidden risks, especially if those suppliers are subject to laws that require them to share data with their own governments, like the case of Huawei. And data security is another key part of CSASC, because protecting sensitive data in the supply chain is essential. And in some countries like China have introduced relatively strict data localization laws to keep the critical data within their borders. This aims to for a better jurisdictional control and faster incident response, also lower the risk of foreign government surveillance or legal compulsion. And here I delve into the comparative aspects. So we see in the EU, they have the 2019 FDI screening regulation, and which has identified several risk factors, the critical infrastructure, key technologies, and access to data. And when we think about that we live in a digital world, those can all be linked to CSASC. However, the regulation itself does not raise the issue of CSASC very explicitly, which might cause a fragmented implementation among member states. While we see another directive, the NIS2 directive, that does require essential and important entities to manage supply chain cyber risks. But this directive is also quite vague in terms of the scope of CSASC and the security process, which make it uncertain for member states to implement. And this directive also excludes the small and micro-sized enterprises suppliers, which is a key actor, according to Locknie and others in the CSASC management. And this directive also focuses more on the end users of technology, like the hospitals or utilities, rather than the main manufacturers or software publishers who shape the security standards. And another breakthrough legal act is the Cyber Resilience Act. However, it suffers from the same problem. There's a vague scope of CSASC and the implementation issue. However, the good side about it is that it introduces the CE marking system. Although it is only focused on the products, but this can serve as an example that certification system can help to bring the qualified product into the market. And so in summary, we found that the EU legislation reflects CSASC consideration, however, only in an implicit way. So the scope of CSASC is still unclear and leave a bit discretion to the member states. While turning into China, China is adopted a different track. So it adopts a data localization above all approach. So the national security review for FDI does exist, but there is no specific CSASC considerations. So the data localization is the key tools for cybersecurity control in China, and the MOC, that's the commercial department of China, is using the data localization as an approval condition in the FDI screening. While turning to the US, as just demonstrated by James, the FDI screening is managed by the CFIUS, and since 2018, the scope has expanded by the Congress and executive order to include cybersecurity and supply chain risks, especially if they relate to critical technologies or countries of concern, above all the PRC. So transactions can be blocked or forced to unwind. And there are also agencies like NIST and CISA. They create strong voluntary guidelines for the supply chain cybersecurity management, but they are non-binding, so the compliance can be varied greatly. So actually, the US framework is more comprehensive in terms of the CSASC, but its decision-making can sometimes be perceived as arbitrary or political, especially in terms of China. So under the current geopolitical tension, it can be even more unpredictable. And so here we are. And so we found that the scope of CSASC is still quite unclear and its application is fragmented. So this can lead to a potential violation of IIA principles and in general, but I'm not going to focus on this. And when we look at an international investment agreement, the modern international investment agreements and provisions on the CSASC is still not that satisfactory. Most of them focusing on the cross-border data flows norms. And the only breakthrough is in the Indo-Pacific Economic Framework. And it specifically raises the issue of CSASC, but there is also a lack of standards. So where does this leave us? And what should we do about the CSASC? According to the Magnet and others, there are several elements that should be included in an effective CSASC management framework. A multi-stakeholder involvement, multi-layer consideration, standardized yet flexible cybersecurity control, and strengthened collaboration in risk identification and response mechanism. Based on this paper proposes a CSASC FDI screening mechanism accommodated to a multi-layer interoperable CSASC framework at the international level. I know that the multilateralism is not working well, so I'm proposing such a framework into a plurilateral agreement like the IPEF. So the first step is to establish an internationally recognized CSASC standard or certification system. And it can be either referred to standards body under the ISO, NIST, or NISA, or a set of individual standard or system. And then incorporate such standard or system and also relevant procedure guarantees into IIAs. There can also be exceptions, but the scope of the exception and the principle of proportionality and necessity can therefore be more clear due to the existing of a more CSASC specific standardized system. And then the states can accommodate these standards into their FDI screening mechanism using the compliance of these standards or system as a condition for approval of the investment. So the Indo-Pacific Economic Framework has taken a strong step further. The more specific CSASC standard or certification system can serve as a supplement to this main agreement. But I also understand there are a lot of instability, and so this is just an initial idea in my mind, and I also want to listen to the valuable audience, the opinions. And I think my time is up, so thank you.
Thank you, Jiaqi. We have about 15 minutes left. I'd like to now perhaps invite questions for the third and the fourth panelists. Yes, please. Could you get a mic too?
Okay. Hi. Thank you all panelists. It's been a very interesting panel for me. I'm Tammy Grosswald-Azeri. I'm a corporate and financial, comparative corporate law and financial law scholar. And my question is, so I'm not an international economic law scholar. But what I see, I think, in recent years is this spillover of national security exceptionalism and in investment screening spilling over not only through IEL, but also from corporate law perspective into policy. And by that, I refer to, for example, in the US, there has been in recent years efforts to apply corporate law doctrines in order to block certain transactions for national security considerations. So basically forcing corporate boards to consider national considerations. And there has been different doctrines, and I don't know if you've read, but Trump has been taken a golden share in US Steel in response to Japan's Nippon Steel takeover. And so I was wondering, first of all, if you see it in your respective countries as well, if you see that type of spillover of investment screening, from IEL to other avenues, and if so, how?
James, do you want to start first from your analysis?
Actually, I have not really seen this in my research. It might be the case, but unfortunately, I haven't really seen this. I will take a look into this. It is very helpful. Thank you.
I mean, just from my practice, I have some experience, I suppose. So when you do a transaction that is difficult, you have to, well, for any transaction that needs to be notified, you need to negotiate in the commercial contracts how you're going to divide the investment screening risk, right? So under the share purchase agreement, there are multiple options. You can say the purchaser has a so-called hell or high water obligation. Hell or high water just means the purchaser needs to do whatever is necessary and whatever is in its capacity to do in order to procure approval, including inter alia, by offering and accepting any condition as is required or as is requested or as may be deemed necessary in order to get the approval. Right, so then you have in your contract a very clear obligation on the purchaser to do whatever it takes. Now, in a purchaser-friendly SPA, that's typically like what we would put in there, and then of course the other party will say, no, I mean we just have the CP in there, the condition precedent, right? For those that are not corporate lawyers, condition precedent means a condition that needs to be fulfilled in order to actually transfer the shares, and you say that the CP is approval, and that's it. Right, and you have like a mutual obligation to provide each other with information and to cooperate in the procedure, but not a substantive obligation in order to get along with whatever the government requires you to do. So that's in the corporate law contracts for the transaction. And then if you then move over to the actual procedure, and let's say that there are mitigating measures, it depends a little bit on how, it depends on a country on how those are arranged or negotiated. So indeed, in Nippon Steel, it was negotiated with the U.S. government to give them a golden share. In some cases, it can also be a public law decision, which tends to be the case in a lot of civil law jurisdictions where the government would adopt a conditional approval decision and you have a public law document that binds the company specifically to certain actions. But what is quite common is something in the middle, namely a negotiation between the government and the company, especially the investor, on what type of measures they need to implement. So actually, cybersecurity measures is common in there, right? So there's an agreement between the investor and the target company would typically also be bound by it directly, and the government to implement cybersecurity measures, to implement board requirements that I mentioned before. And that one can have both civil law status, being a contract with the government, as well as being then adopted inside the agreement itself or being annexed to it, creating also a public law obligation to comply with it. So I think those, at least within my practice and within my study, these are two elements where I see corporate and private law features in investment screening.
Thank you. Would you like to add? Oh, you have a mic.
I actually found Jochem just lead us into a very interesting perspective, and I agree with him. And I actually haven't really looked at this corporate law perspective, so I think this is a very good point for my research. Thank you.
Oh, yes.
Thank you. It's very interesting presentation. James, from the models that you look at, which one you think is the best one? Like in the sense of the balance, FDI screening, and the other side is like for investment. And it seems fragmented. Do you think in the future this might be like more harmonized, or forever it's just gonna be a reservation? It's gonna be exception rather than the rules. Shai, you propose about the ISO that standard. I'm just wondering whether this is a private standard. How is going to facilitate this fragmented government approach model using this private standard? Thank you.
Maybe you.
Thank you for the difficult questions. Well, if you ask what is the best model, I think if I have to assess, I would say that the one that probably will be very less likely to be seen from the perspective of compliance with the investment obligations. I would say that the Singapore model probably is the best, but a lot of countries will not be happy with this, of course, especially in Southeast Asia. But I think it is really, it really shows that the introduction of the investment screening law is really meant to address security concerns, and the security concerns are not being put. Of course, it is still, the government actually mentioned in its explanation about the regulation, they did a public consultation as well, that security itself is a broad concept. But at the same time, if we look at the design from the fact that one, they do not apply only to foreign investors, but also for any kind of investment in some very sensitive or strategic sectors, then that shows there's a genuine security considerations when they apply it. And secondly, if we look at it, it is a very, it seems like the review itself is a very light review. So the review, first of all, it is only targeted for certain designated entities. So the government, I didn't go into very much detail in my presentation, but by designated entities, the government actually mentioned the specific name of the companies, and they have a list that they continue to update. So the last time I checked about, today actually, I checked, there were 9 companies which were listed there. ST Logistics, those also in the defense and military sector, oil and gas like Shell and Exxon, they are designated entities so that when there is a transaction happening, if it is a merger and acquisition, for example, of going into these companies, then this will have to be reported. Yeah, so that's the first question. The second question probably is the more difficult, whether or not these investment screening mechanisms will be harmonized. I'm very pessimistic on this because I think at an international level, the only way that we try to discipline investment screening mechanism, and it's not even, I don't think there are treaty negotiators actually think about disciplining investment screening mechanism because the starting point is really security. So each country has its own definition of what constitutes security. So, so in that sense itself, it will be very difficult to reach a harmonization. Thank you.
Then we have one last question.
Yeah, thank you for the wonderful question. I think it's very interesting. I think while ISO standards themselves are voluntary and a very private standard, but countries can still enter some kind of common consensus and incorporate these kind of standards into the future signed IIAs, or maybe incorporate it into the domestic law, and to use them as a condition, like to comply with all kinds of these standards as a condition for the approval of the investment. That's the idea currently in my mind. Thank you.
We have one last question, because after that, I'm told by my bosses that we have to take a group photo. So-
Okay. Hi, I'm Tim Edelman from the European University Institute. My question goes to the both of your research designs, namely being that you emphasize that you're on the comparative aspect. And I would like to know from you, what is the advantage from your perspective of approaching this topic comparatively? Since, I mean, jumping on a bit the last question on what's the best or what's harmonized or not, I'm not so sure if you would find a uniform answer there, in the sense that you were saying like what's the best, because, and it goes back to your answer as well, James, right? It's depending on what your sense of security is, and if we were to reframe the discussion a little bit away from security into sovereignty, then maybe these kind of discussions about do we want a very light touch or do we want something like that, they would be seen probably very differently. Yet we have this kind of security lens, and maybe just as a suggestion, you could look into the EU's efforts at the moment which tries to harmonize it under the revision of the EU screening regulation, which receives quite a bit of pushback, despite more and more emphasis being on, it's not about just your member states' securities. There is also a component which is uniquely European, in the sense that supranational, that none of the member states itself capture. But still, you receive pushback even in the EU.
James, maybe?
In terms of the advantage of the comparative analysis, I believe that this can, first of all, it can provide us a clear picture of what are really the investment screening mechanisms available out there. And secondly, this can be inspiration as policy options and also consideration for other countries which are considering to revise their ISMs, if anything, in the future. I thank you as well for the explanation about security. I think that is something that I can look further as well to enrich my paper.
I think Agata would like to add something.
Sorry, just very briefly, and it's been coming into my head in and out. It's no matter what the framework is, I think and this is, James and I are looking at the ISDS of it all, does it really matter? Because doesn't it then come down to what are the powers of the tribunal to review it? It's a domestic law question, right? So is it a question of fact? Is it a question of law? And then it's whether it's whether the institution of the FDI screening, the mechanism itself is the same across different countries or not. Well, I think there's this other step that we need to address a little bit of what are the powers of the tribunal to review that.
Yeah, from my perspective, I just feel like the cybersecurity is such an interconnected thing. So it really needs the joint force of all countries to combat these risks. So from a comparative perspective, we really can really know that why a country is adopting this approach, but why not another, and what kind of consensus can be reached here. That's what I consider.
I mean, I share James' his sense of pessimism about further prospect of harmonization. At the same time, I think it's important to compare and to see what is possible in order to create some best standards. So I think there are some merits in that type of research still. Yes.
So thank you very much, all the panelists. I think we should show appreciation for their presentations. Thank you so much. And thank you for your questions and your participation. We'd like to request that you don't run away yet. I believe there's a group photo that's being arranged now.
Thank you so much for attending the side event. We'll now take a group photo. Panelists, would you move to the row behind the camera, please? Thank you. Now you can move to first floor. We'll have other staff members to guide you to the welcome reception. Thank you very much.